Hello and welcome. I'm so glad you all decided to join us today for Arizona Foundation for Women's Financial Independence Seminars. We have a wonderful series for the 2021 year, so I do encourage you to look at our website and check out the upcoming events. Together with our members of the Professional Advisors Committee, we bring you information from experts that can help you make critical financial decisions that affect you, your business, your family, and your whole community. At Arizona Foundation for Women, we work to advance the status of Arizona's women through research, advocacy, and philanthropy to ensure their safety, health, and economic independence. We just celebrated our 25th anniversary last year. Whew, what a year. It has been really tough for a lot of people, but it has been especially tough for women. Excuse me, I'm sorry. It's been especially tough on women who have had to drop out of the labor force altogether to care for children and elderly family members. Did you know that 41% of women in Arizona have been a victim of sexual violence? Almost half of the perpetrators were a current or former intimate partner. Females in Arizona also outpace males as undergraduate enrollees in 2- and 4-year post-secondary institutions, but still only comprise 21% of C-suite executive positions nationally. In Arizona, 21% of low-income women lack health insurance. 29% of Hispanic women in Arizona have no health care provider. And only 28% of Arizona families can afford infant care that starts at an average of $9,500 a year. Our work in research, advocacy, and programming is needed now more than ever. If you have clients or friends who are interested in helping Arizona's women, please feel free to reach out to me at jennifer@azfw.org. And now I'd like to welcome Stephanie Bivens. Actually, one more thing before I do that, just to navigate, maybe a lot of you are new to On24, you can move around all the little boxes on your screen. And there are also boxes kind of off your screen onto the right. So if you scroll to the right, you'll see handouts, a way to ask questions, further information on Stephanie Bivens, and further information on Arizona Foundation for Women. Now I would like to welcome Stephanie Bivens. Stephanie is a certified elder law attorney, and she has her own practice that includes 4 other attorneys in the Phoenix area. Ms. Bivens is nationally recognized in her legal field. She's a frequent speaker and writer. She's former contributing editor for Attorney at Law magazine in Phoenix. She regularly speaks at community education events and serves as faculty for continuing legal education events for attorneys and fiduciaries, including the State Bar of Arizona, Maricopa County Bar Association, the Arizona Fiduciary Association, the National Guardianship Association, and the National Academy of Elder Law Attorneys. She's authored 2 publications that are available on Amazon, Private Information Guide, The Personal and Financial Organizer, and How to Pay for Long-Term Care in Arizona with Free Government Benefits. That is definitely a topic worth pursuing. So thank you all for joining, and now I pass it off to Stephanie Bivens.
Hi, everyone. So glad you could join us tonight. We're going to talk about the top 10 mistakes in estate planning. I've been an attorney in the Valley for 25 years now, which makes me feel extraordinarily old or seasoned when I say that. So I've seen a lot of good, a lot of bad, and a lot of in between. And we're going to talk about the top 10 mistakes that I've seen in my practice so you don't make them and your families are going to be best served along with those that you care about. A little bit about my firm, just so you understand the background that I'm coming from. I am an estate planning attorney who handles estate planning, probate, trust administration matters, but I'm also known as an elder law attorney and special needs planning attorney. So what that means in the real world is we don't just draft the documents. We're actually working with the next generation in administering the estates and in fulfilling their roles as successor trustee or agents. So we're operating in the real world. What that means is I'm going to give you some very practical tips and pointers tonight on getting everything done. So the first mistake that I see people make when they're thinking about estate planning is procrastination. Everyone thinks, I'll get to it. It seems overwhelming. It seems like it's going to take a lot of time or a lot of money. And so it's just one of those things people tend to put their head in the sand and think, mañana, right? I'll do it later. Well, Benjamin Franklin is attributed with a saying, by failing to prepare, you are preparing to fail. And in estate planning, there is no more truer statement. It will also usually cost a lot more Benjamins to fix an estate when there is no estate planning documents and somebody passes away or becomes incapacitated. So we know none of you here are going to procrastinate. So when we talk about estate planning, I want to make sure we're all talking apples to apples here. In Arizona, there are a set of documents which most people should have. So we're going to talk about those, and those are listed on the slide here. That's a healthcare power of attorney, mental health power of attorney, living will, durable financial power of attorney, a last will and testament. Everyone over the age of 18 should have these documents. And most people should also have a trust. And we'll dive in and unpack all of these documents. There are handouts available to you, so don't feel like you have to mad scramble and take notes if I'm going a little quickly. I do want to make sure that we have time to answer people's questions, so feel free to put questions in the Q&A chat as we go along, and I'll address those probably at the end, or we may even cover them as we go along. But just to make sure everybody understands when we talk about these documents, what they do, so we know why they are important. A healthcare power of attorney allows you to designate someone to make medical decisions for you if ever you could not yourself. Pretty simple, right? A mental health power of attorney in Arizona is very unique. I have all of my clients do one, even my clients who've never been diagnosed with any type of a mental health disorder at all. What this document does is it allows your agent to arrange for inpatient psychiatric mental health treatment for you if you ever had a significant mental health episode and needed that level of care, so that your agent can get you in, get you the treatment you need, get you out without requiring a mental health guardianship proceeding through the court. As an elder law and special needs planning attorney, my firm handles a lot of guardianship conservatorship work. We'll unpack that a little bit as we talk. But I can guarantee you the only one having a good time at court are the lawyers, right? My client families are not loving that experience. So one of the best ways to avoid court is by having your estate planning documents in place. A living will is also a medical directive, and there's always a lot of myths about what is this document, because it sounds like a living trust and it sounds like a will, meaning a last will and testament, and it is neither of those things. We use the living will as a document where you can put in writing your wishes regarding medical treatment. So if ever you're not able to express your wishes, the agent that you designate under your healthcare power of attorney, as well as your medical treatment team, will have instruction from you. Most people use the living will for end-of-life medical direction. Most people I talk to and work with say in their living will, if they're in a coma, a vegetative state, they're not going to recover, they're terminally ill, unconscious, there's no reasonable hope of reversal of that condition, they would not want their life artificially prolonged by heroic measures. That's what the living will is. Side note, living will is very different from a DNR, or a do not resuscitate order, also called, I have a dog here, sorry. If you see a chocolate lab jump up, that's Luna, just ignore her. A DNR is used not by most people. The DNR, it's also known as an orange form, simply says if you had a cardiac event, you would not want CPR administered. So we all know people who've had a heart attack or cardiac event. They have CPR, maybe they have medical treatment, and they go on to live a very healthy, happy life after that, right? Great. Those are people that wouldn't want a DNR. Most people who have a DNR in place are only those who are already terminally ill or of a very, very advanced age, or for some other reason understand what that is and would have that document. So that's why that's not on the list. But just to clarify any misconceptions out there. Financial power of attorney. That is a critically important document in Arizona. What it does is say who you authorize to handle your your financial matters for you in the event you're incapacitated or immediately at the same time as you. So most people who aren't getting help from relatives, like a spouse or an adult child who are handling their financial matters themselves, they would have a power of attorney that says only if my doctor puts in writing that I'm unable to handle financial matters would this power of attorney spring into effect. We lawyers cleverly call these springing powers of attorney. It would spring into effect and allow this person to pay my bills, manage my assets, retirement accounts, brokerage accounts, etc. But if somebody's actively helping you, maybe you and your spouse work together, or maybe you've got an adult child who's always, going to financial advising meetings with you, or you feel like they're just more astute, you're more comfortable with them helping you with financial matters, you would want a power of attorney that was effective immediately. So you have a choice there when you set it up. Last will and testament, most people know what that document is. A last will and testament says who you designate as your personal representative. Here in Arizona, we're very advanced. We use the gender neutral term as PR, or personal representative, to designate the person who's going to marshal your estate assets, pay the debts, and make distributions to your heirs under your will in accordance with the terms set forth in your will, right? A last will and testament is not valid during your lifetime. A financial power of attorney is only valid during your lifetime. So you need both as part of a complete plan. And then a lot of people will actually benefit from a trust. So a trust, the type of trust we're going to talk about, and there's a myriad of different variations, but the most common type of trust we use in estate planning is known as a revocable trust. Sometimes you'll hear the term living trust. I use the term revocable trust because I think it better describes what it is. It's a trust instrument that you can change throughout your lifetime as long as you're competent, right? Just like all these documents, you can change them at any time. And in fact, we usually recommend people look at them about every 3 to 5 years because they should be updated as tax laws change, your assets change, your family dynamics change, your wishes change. These documents should live and breathe with you. I always equate it to like a routine maintenance on your car in order to keep your car running at its optimal best and performing best for you when you need it. Same thing with your estate plan. You need regular checkups with your attorney to make sure it's going to run best for you when you need it. Make sense? So here's basically what a trust is. The simplest way I can describe it is it works like a financial power of attorney and a will. So what do I mean when I say that? With a trust, you start out as your own trustee. You're in charge, you manage all of the assets. Only the trustee has the authority to manage the assets and accounts owned by the trust. That doesn't make sense? I promise it'll make sense to you by the end of our discussion. During your lifetime, you're the beneficiary. So you put your assets into the trust, you get to use them, you're the trustee, they're all for your benefit. Same thing as they are now during your lifetime, right? No real practical difference, except on your investment accounts or real estate, the name of the trust will be reflected as the owner instead of you as the individual. But should you pass away, here's where your trust starts sounding like a will. It's going to say exactly the same thing your will would say. If I'm not able to be the trustee in charge, my successor trustee takes over, and here's, after all the debts and expenses are paid, here's where the trust assets go. Just like a will, who's going to inherit either outright or in subtrust. We'll touch on that later. The key differences with a trust versus a will are this. One is you'll name a successor trustee. If you're incapacitated, or as I like to say, you are still with us, but you're not with it, for any period of time during your lifetime, right? You're not able to pay your bills, manage your assets. Your successor trustee will automatically be able to step up. Banks, financial institutions, and title companies are more cooperative and work better in the real world with a trustee than just an agent under a power of attorney. There's no basis in the law for that. That's just what happens in the real world in our experience. Also, should you pass away, no probate is required. Why? Trust law already gives the authority to the successor trustee to marshal the assets, pay the debts, touch the accounts, do what they need to do to make distributions and administer your trust. Your will sounds good. And here's what most people don't know about a will. In your will, you name, let's say Susie Q as your personal representative, right? Susie Q cannot take the will to the bank with your death certificate and say, I'm named as personal representative, I need to open up an estate account, give me access, I have to pay bills. The bank's gonna say, that's lovely, Susie Q, go to court, have the will authenticated in court in probate, and come back with your court issued what we call letters of appointment. So your personal representative has no authority to act on behalf of the estate until the will gets submitted to the probate division of the court. That's why we call it probate. Most people, when they're doing estate planning, their two goals are avoid probate. It's a good goal. Two, make things as easy as possible on those you care about who are going to work hard to fulfill your wishes, right? To either take care of you or those you care about. So trusts are really valuable tools. We'll talk about those a little bit more. So what happens if you procrastinate and there's no estate planning documents, right? We're probably going to end up in probate court. There's a much higher likelihood that there's going to be delays, additional legal fees. We in the office refer to probate court when you are alive as a living probate. People don't realize what happens. If you become incapacitated and you cannot sign a power of attorney or a trust to put somebody in charge of your affairs, it's too late, right? Nobody has the authority to sign these documents except you. So if you're with us, but you're not with it, and nobody else has the authority to pay your bills, manage your assets, your property, etc., I have no choice as an attorney. I have to go to court and get somebody appointed as a conservator for you. It's very expensive. It's not a fun process. It could be very easily avoided with just a simple power of attorney. What if you become incapacitated and there's no medical directives? Well, our legislature has so kindly decided who gets to make your medical decisions for you. These may not be the people you would pick, but here's who's going to have decision-making authority over you. If you are married, it's your spouse. It's not always everybody's first choice, particularly in late in life second marriages, right? If you are not married and you have children, here's my personal favorite, majority vote among your adult kids. Now, I know some of you listening just went, ooh, right? We have 3 kids, or we have 2 kids. We love them. They love us, but they do not agree, right? They don't have good communication skills. And it's not kids we like or kids that like us. It's all kids. So that can obviously create some really interesting and traumatic conversations, particularly in hospital settings when big decisions have to be made. Not a good outcome. Much, much better that you pick and have a hierarchy of people that would be in charge that you know, like, and trust, right? Don't leave it up to a stranger being the court. So spouse first, majority vote among adult children. If we have no spouse, no kids, we look up. No parents, we look sideways to siblings. No siblings. Honest to God, the statute basically says anybody who walks in the room and acts like they know you and like you. It's not what the statute says, but that's kind of what the outcome is. Far better you pick, right? What happens if you pass away and you didn't have a will or a trust? Well, our legislature has also in that instance so kindly decided who inherits from you. So a lot of people think if you pass away with no will, the assets go to the state. I don't know where that rumor started. That's not true. However, here's where it goes. If you are married and all of your children are of that same marriage, everything goes to your spouse. If you're not married, it all goes to your kids in equal shares. If a child has also died before you, they had kids, then their share is going to go down to your grandchildren. However, in second marriages, it gets much more complicated, and we'll talk about that in a few minutes. So honestly, we probably end up in court Unfortunately, sometimes we end up with unforeseen circumstances. The wrong people end up in charge, or unforeseen people end up inheriting. It's just not a good outcome in all instances. It's far better that you do the plan. So now I've talked you into doing your plan. You know what documents generally you need, and you think you're going to save a few pennies. You're going to DIY this project. This is my number 2 mistake. In life, there's a lot of ways we can cut corners. We can save money by learning how to DIY things. You know, the YouTube is fabulous, Pinterest, all these great resources we have. I always equate DIYing to, if you're not a trained electrician, you can go to Home Depot or Lowe's, talk to those nice people. You can go on to, YouTube, watch instructional videos, rewire your entire house yourself. What's the risk? You're going to have a fire inside the wall of your home, and your house is going to be burning down before you ever knew it's going to be a problem, and it's going to be too late to have the fix. Same thing when you DIY it with your estate planning. The problem is we're not going to know there's a problem until you're incapacitated or you've passed away. And now it's too late to have an easy fix. I cannot tell you how many cases we've had to take to court, how many unfortunate circumstances there have been because somebody downloaded something off the internet. God loves Susie Orman. These other check the box, internet, do your estate plans. The problems with those DIY situations is you don't know, unless you are a trained attorney in this area, what questions to even ask when you're clicking the buttons. You could come up with a document that doesn't end up reflecting your wishes, or maybe there was an entirely better strategy and you didn't know that because you didn't know which boxes to click. The other thing I see is people will sometimes try and save a little bit of money and they go to what's called a licensed document preparer. Here's what people don't know about licensed document preparers in Arizona. They only have to have a high school diploma, and they are prohibited by law from giving legal advice. Does that sound like somebody that you should be entrusting your estate plan to? Probably not. They can do other things, but I wouldn't necessarily recommend a complete estate plan because, again, you're not going to know the questions to ask, and even if you did, they are not allowed to give you the answers, even if they knew them. So DIY is never recommended. We lawyers make a lot of money fixing DIY projects. I'd rather be on the planning side and not have to do the fix. It's just a better outcome. So let's say you worked with an attorney and you have a beautiful estate plan. What's the number 3 mistake I see is you got it, it's in the binder, it's beautiful, you shove it in a drawer or the closet of the house and you never look at it again. Well, life changes, tax laws changes, your assets change, your wishes may change, and if you don't pull that plan out, dust it off, get a quick review with your attorney every 3-ish to 5-ish years, I like 3, all different things can happen along the road of life, right? People get divorced, they move, there's marriages, births, tax laws changes, and this year we're probably going to see, or in the very near future, we may see major changes in our estate tax code. So we're sitting down and counseling with our high net worth clients right now because there may be a very limited window. If you have an estate of, I will say, 5 million or more, this is 100% the year you need to be sitting down with experienced estate planning attorney, even if you did your estate plan within the last 3 years, to look at your assets and really take a look at, actually 3.5 million and over. Our estate tax may drop that low. That comment will make sense by the time we're done. But we're in this sea change. Things are going to happen. We don't know what it's going to look like, but that's why you need to be staying on top of things, because it's really important. You can save a lot of money and achieve better outcomes. Number 4 mistake is people think they've got these documents, it's in the binder, it's beautiful, and they shove it in the closet or in their lockbox at home, and they don't take the time to look at how their accounts are actually titled. It makes a difference. If your will or your trust says, when I die, everything goes to my 2 kids, and I have 2 kids, Jack and Sarah. We'll forget my husband for a moment. And my estate plan says everything goes to Jack and Sarah 50-50. But I had a life insurance policy, and for whatever reason, when I took that out, I designated Jack as the 100% beneficiary to that life insurance. I die. Guess who's getting the death benefit from that life insurance policy? Jack. Because the beneficiary designation on insurance policies, retirement accounts, annuities controls. My trust and my will had nothing to do with that. Who's going to need to be really nice to Jack on his birthday and the holidays? Sarah, right? Because it's legally Jack's money at that point. So you have to look at every single thing you own and make sure that it coordinates and matches your wishes. It's very, very important. And a lot of times that goes ignored. Mistake number 5. Let's say you do have a trust, right? It makes sense. You have a trust. However, the trust only owns what you literally title to the trust. So there's something we attorneys refer to as calling trust funding, right? Funding is a term of art. All that means is, have you put everything you can into the trust? Here's why it's so important. We're going to talk about probate here. So remember when I said everything in the trust avoids probate? Everything in your will that your will is going to control doesn't necessarily avoid probate. So we're going to talk about really quick the 3 types of ways assets are, well, maybe 4, I guess, technically. 4 different ways assets are transferred to people when you pass away. The first is joint ownership. If you and your spouse, or you and an adult child, for example, are both co-owners on a bank account, and you pass away, right? The remaining joint owner presumptively owns that asset. If your will says, my estate goes to Susie Q, I'll use my kids, my estate goes to Jack, but I co-own a bank account with Sarah. I die. Sarah gets the bank account. Why? Because under banking law, the presumption is the co-owner now owns those assets. It didn't go to the will. Another way assets get passed through non-probate transfer, what we call operation of laws, through beneficiary designation. So you're familiar, life insurance, retirement accounts, annuities, those types of investments all have beneficiary designations. And when you take out those investments, you fill out the beneficiary designation form. Primary beneficiary is this person or these people. If that person dies before me, the contingent or the secondary beneficiaries are these people, right? Or that person, you put that on that form. That is a contractual arrangement between you and the company. If your will says, my estate goes, again, to Jack, but you put Sarah as the primary beneficiary on your retirement account, guess who's getting the money? Sarah, from the retirement account. Why? Because it was told where to go first. So joint ownership, beneficiary designation, automatically by operation of law controls who inherits those assets. They are ways to avoid probate. A trust also avoids probate. Again, all the assets have to be in the trust. So this leads to what is funding of the trust. Funding of the trust means if you have a piece of real estate, your home property, and you own it individually on the deed, and you don't do a new deed conveying ownership from you to your trust and you die, the trust can't control it. You died, it's in your name alone. It doesn't know who owns it. It's sitting there wondering who now owns me. Your will controls that. So the will only controls what we call the leftovers, where I call the leftovers. It's not really a legal term, right? It's the leftovers. It's a thing that was in the deceased person's name at the time of their death that wasn't first told where to go by operation of joint ownership, beneficiary designation, or trust ownership, right? So people will pay a lot of money for a trust. It's beautiful. It's in a binder. It's 3-ringed. It's tabbed. It might have a gold leaf, trust title on the front of it. leather bound. It's beautiful. But if that person paid thousands of dollars for that trust and they left their house in their name, they didn't deed the house into the trust, they left their brokerage account in their name, they left their savings accounts in their name, their vehicles in their name, and they didn't, put it into the trust, and they pass away, and those assets are now in their estate. If the estate assets have more than $100,000 of equity of real estate or more than $75,000 of other assets combined, so think checking, brokerage accounts, etc., that are sitting there in the deceased individual's name, we have to take that will to probate. There's no other legal recourse. Those are the mandatory probate requirements for estates in Arizona. Again, that's $100,000 of equity in real estate or more than $75,000 sitting in the deceased person's name. That's just part of their estate, because again, no beneficiary, it wasn't in the trust, no surviving joint owner. Now, this person paid a lot of money for a trust. They have a little, by the way, when you have a trust, you have a will as well. The type of will you have when you have a trust is called a pour-over will. And I always tell people that's intended to be a P-O-U-R, not P-O-O-R will. The will that goes with the trust just says, my estate assets go to the trust. So the beneficiary or the devotee under the will is simply the trust. But here's the problem. If we have a nice big piece of property worth $150,000 of equity and that person passed away, I get to probate your will. So we do a full probate estate, dump the probate assets into the trust, and then we get to do, guess what? A secondary trust administration, a whole other post-death administration through the trust. It's like doing it twice. Not a good outcome. So if you have a trust, it is critically important that you look at every single asset and make sure that it is properly funded. Now, retirement accounts, and everybody always points this out, under federal law, you may not change the ownership of an IRA, 401k, 403b, any retirement account from the individual to the trust. That's okay. You remain the owner. Your beneficiary designations are important. Under the Secure Act, which was implemented last year, you may or may not want the trust to be the beneficiary. Again, if you have retirement assets, the Secure Act, which was implemented last year, made major changes to how people can take and inherit and what the consequences are when they roll over a retirement account that they inherit from someone else. It's really, really important you get back in there to your estate planning attorney or your financial advisor, review those beneficiary designations in conjunction with your wishes and the Secure Act, because if you designated your trust, it may be time to update that. It's a longer discussion than I have, but we'll throw that extra little piece of information in there for you. So mistake number 6, failing to plan for contingencies. And this would seem obvious, but it's not, right? What do I mean by this? Attorneys, we sound paranoid. There's a reason. I always tell my clients, listen, my job as an estate planning attorney is to literally plan for the worst and hope for the best. So what do I mean by that? We all kind of have an idea, right, of if I pass away, or I became sick, this person's going to be able to be there for me. They're going to be able to pay my bills or handle my estate. These are the logical people that would inherit. Right? But what happens if those people get sick? Or pragmatically, they move out of country and it's too difficult for them to do the job. We have to have backups to what we call your fiduciaries. So people you name as your agents for financial management, medical decision-making, or powers of attorney, your personal representatives under your will, your successor trustees under your trust. You don't want to just name one person, right? Because what happens if something happens to that one person? You need a backup, or at least you need to consider alternatives. What happens if you don't have a deep roster? No, not everybody does, right? Have people that they trust in their family, right? I know somebody in this audience right now is going, oh, I don't think I'd put anybody in charge of this stuff, right? Not everybody has a deep roster of friends or family. There are professionals, licensed fiduciaries, bank and trust companies that can serve these roles for you. Sometimes it makes sense not to have family do this, right? They may not all get along. It might be very wise to put a bank and a trust company in charge of the estate so that a professional neutral party is administering things, and the relatives then only serve in the position of being the recipient or the beneficiary. So you have to think about, plan A and then plan B. Also with regard to leaving assets and how people are going to inherit from you, right? We're going to assume, let's say it's going to go to the kids. Well, what happens if a child, heaven forbid, passed before you? Where does their share go? We need to say that. What happens if, and I literally tell clients this, you and everybody is at the family picnic and the meteor lands, right? Nobody's there to inherit that's named in the document. Maybe we need to put in a catastrophe clause, right? So we really need to think things through in a way where literally you will seem paranoid in your documents, but it's just thorough planning. Mistake number 7, failure to consider blended family issues. So these are the Brady bunches, right? Second marriages, third marriages, or I have some very, what I call optimistic clients, and they're in their 5th or 6th marriages. This one's the one, right? Okay, I'm not making fun of people. I'm just trying to be tongue in cheek here. But oftentimes in these later in life relationships, you've got children or others that you want to make sure ultimately benefit from what you own. So here's where we see problems. Second marriage, they do a simple estate plan that says, honey, if I die, it goes to you. Everything I have goes outright, free of trust, to my surviving spouse. That's great. But now all your separate property, everything you brought into the marriage from your first relationship that you would really like to know, if your surviving spouse didn't need those assets, now, and they later die, they can use them, the income, the principal, but then they later pass away, it's going to go back to your kids. There's a way to do that, right? But you have to plan for that. So blended families can be very complicated. We have to make sure we know what is separate property, what is community property. Do we want to distribute outright, or are we going to put things in trust for a surviving spouse? Maybe we're not leaving anything to a surviving spouse. Maybe we need a premarital or a postnuptial agreement. We can just end up with a lot of unforeseen circumstances if things are not thought out, and a lot of hurt feelings. I have attorney friends who in estate litigation pretty much always just represent the step parent, and the other one pretty much always just represent the kids from the prior relationships, right? Not a good outcome. Much, much better to plan for it, have everything set out. So mistake number 8 that I see people make is failing to plan for their own potential incapacity, right? These are the issues of, if something happened to me long-term and I needed long-term care, meaning help at home, or I needed to go to assisted living, memory care, or skilled nursing, what does that look like, right? We can put things in medical directives. We can actually, as elder law attorneys, we can put planning options into your powers of attorney and your trust to engage in asset protection later against the cost of care to help you qualify for government benefits that may be available to help pay for long-term care. If we don't think the estate is sufficient to privately pay, or you don't have long-term care insurance or investments that would cover that. So, there's a lot of long-term care planning, what I'll say elder law or special needs planning issues that we can kind of build in the just in case in a basic estate plan. If you have any of those issues, I would encourage you to sit down with an attorney that does both elder law and estate planning. That's a very unique area. But also really just think about, who really would be a good medical decision maker for you? Who is good under pressure? A lot of times attorneys just gloss over these issues. And It's really important. The people you put in charge of the money may have great money skills, but they would not be the best in dealing with doctors and medical issues and medical advocacy and all of those issues. Doesn't have to be the same people. You can have different people in charge of money versus medical. Now, obviously, they need to coordinate. So dynamics between them will be important, but, kind of not putting enough thought into what would that really look like. Sometimes I see creating issues. Mistake number 9, failure to consider using a trust. You probably are gathering from my conversation, I am a fan of the revocable trust. Here's why. It is the gold standard in estate planning. Most people think about trusts just for probate avoidance. And there are other ways to avoid probate. And I believe Linda put a question early up on the Q&A that I saw before we started. So Linda, if you're still with us, here's the answer to your question. Her question basically was, trusts are kind of expensive. Why can't you just put beneficiary designation and use joint owner on all of your accounts with a will to avoid probate? Why would you need a trust? You can. You can just use beneficiary designation. But here's why a trust might be better. If you have one beneficiary, let's say one adult child or one grandchild or best friend, sibling, whoever it is, that you think if I pass, I want that one person to get everything and I want that one person to be in charge of it. That might be a good way to avoid probate. And if that's your situation, a trust may not be what you need. But if you have 2 people and you're going to name 50% beneficiaries on everything, 50% POD on bank accounts, TOD on investment accounts, a beneficiary deed to your home, by the way, is a way to avoid probate for a house. You can either put your house in a trust or you can use a beneficiary deed. Beneficiary deed has to be signed, recorded while you're alive to be legally in effect. But literally it says effective on my death, this property is now owned by this person or these people. Here's the problem when you have more than one person taking by beneficiary designation. You still have bills that need to be paid. You still have a tax return that needs to be filed. There is still post-death stuff that needs to happen. Now you have 2 or more people that have divvied up and collected everything. They all have to agree. Who's contributing how much to pay which bills? Because guess what? The bills still need to be paid. You can have an administrative nightmare. Think about this. What if you wanted to leave your estate to your 3 kids? You don't want to bother to have a trust, so you do a beneficiary deed. Now, all 3 kids have a equal 1/3 ownership on that deed. All 3 kids have to agree to the realtor. If they're going to sell it, they have to agree to the listing agreement. Counter, things, offers, they have to all go to the closing. It can become an administrative nightmare. It could be much better to do a trust, put one person in charge. All 3 are going to end up getting what they're entitled to, but you had one point person, namely your successor trustee, that's collecting all the money, going to pay all the bills, no problems, much easier. It's, everybody's entitled in accounting. Everybody's going to see what happened, but administratively, it works much smoother. Trust me. So estate planning is a lot like snowflakes. We have these documents. These documents sound pretty standard. Trust me. Your situation is different from your neighbor's situation. It's based on your goals, your objectives, your marital status, your family dynamics, the value of your assets, what you own, where your assets are located. So, a will might be perfect with probate avoidance, non-probate, just beneficiary designations on things. That might be what I would recommend. The next person could come in and a trust is going to be by far their best tool. So one person in charge of taking care of everything post-death through a trust is one upside of a trust. Probate avoidance is clearly the other. Here's the last big 2. If you're incapacitated, your trustee is going to have an easier time of dealing with your financial institutions than the same person does as agent under power of attorney. So if your goal is to make things as easy as possible on those that are going to help you, absolutely a trust, 100% is the way to go. Also, a trust is a way you can actually protect yourself in the event of future vulnerability or incapacity. So as I mentioned, I'm an elder law attorney. When I'm working with my clients who might be older, who are in the early stages of dementia or Alzheimer's or some other progressive cognitive impairment, where as their condition progresses, they will likely become vulnerable, have short-term memory issues, maybe, accidentally mismanage their own assets or have somebody else steal from them, frankly, financial exploitation. Because only the trustee has the ability to manage the assets of a trust, if a doctor puts in writing that you're no longer able to handle financial matters, let's say you're becoming incapacitated, your neurologist says, you shouldn't be handling financial matters anymore. Your successor trustee takes over. You come off the accounts as trustee. Your successor trustee goes on. Now, if your new best friend you just met in the parking lot walks you into your bank and you tell the bank teller, I want to take $10,000 out because my new best friend needs a truck. True story. Anything that comes out of my mouth has actually happened in my practice. The bank teller is going to tell you, I'm so sorry. Come back with a trustee and we'll be happy to help you with that transaction. Right? So a trust has a lot of upsides that wills and powers of attorney just simply don't have. Wills and powers of attorney are not bad. They're a valid part of an estate plan, of every complete estate plan, but sometimes layering that trust on can actually really help. Mistake number 10 is what I call failure to leave the breadcrumbs. So what do I mean by that? You did everything right. You've got great documents. They're perfect. They say what you want. You have funded your assets to your trust, or you've got beneficiary designation. So everything is the way that it needs to be, right? So, okay, something happens to you. You become incapacitated. You're nonverbal. Somebody needs to take over and manage things. What if they don't know anything about it? Right? They don't know where you bank. They don't know who your investment advisor is, your CPA, where all of your accounts, your assets. They don't know who your health insurance provider is, your doctors, right? Their job is made so much more difficult because they don't actually have the practical information they need to do the job. So it costs a lot more in stress, time, and delays. Similar if you pass away and they don't know everything about you. Right? It takes more time. It used to be in the old days, again, I've been practicing for 25 years. So in the olden days, we would just tell clients, hey, answer the mail, right? Over 3 or 4 months, over at least a fiscal quarter, we're going to end up getting all of these statements from all the financial accounts. We'll eventually figure out everything there is now. How many of you get email statements without statements in the mail, right? We have digital assets. Who has your passwords? You've got photos stored on the cloud. How are they going to get your family photos? I mean, there's just all kinds of things now that it becomes really tricky to get people's information so that your fiduciaries can do their actual job. So we created something called the Private Information Guide because I couldn't find anything out there on the market. It's available on Amazon. If anybody's interested, it's not very expensive. Or you can just come up with your own list of, all your medications, who to contact in case of an emergency, all of your accounts. Obviously you want to keep all that information very private. Don't put it out in your coffee table book because someone could assume your identity if you put everything that needs to be in there. That information should be kept current and should be kept with your documents. But that's kind of the last piece of the estate plan, right? Is to give people, whoever would be in charge, the information they need. You don't need to give copies of your documents away to people now. Everybody always asks that question. But you do need to let people know, your next of kin or who your people, your decision makers would be, your trustees, et cetera, where you keep your documents, who your attorney is, your financial advisor, your CPA. You need a team, right? So that your family can have all the information they need when that time comes. Those are my top 10 mistakes. I didn't talk about estate tax, and since we have 10 minutes left, a little bit of time of questions, I'm going to throw in estate tax because someone's going to ask me. In Arizona, we have no state estate tax. Yay, Arizona, right? So when I talk about estate tax, that means at the federal level. Today, this year, each individual can die and leave up to $11.7 million free of federal estate tax to their heirs. So very few people need to worry about estate tax planning as part of their estate. That is likely going to change. If federal law doesn't change, right now it's scheduled to go back down to $5 million per person by the end of 2025. So we know in 4 years, if no changes were made to federal code, it would be down to $5 million per person. Now you can die and leave an unlimited amount to your spouse. So this is to others, right? Anybody besides your spouse. You can also leave an unlimited amount to charity, hence Arizona Foundation for Women, right? That is not subject to estate tax. Charitable gifts, bequests, post-death are escape federal estate tax. However, we have multiple pieces of legislation pending now in Congress where it could drop as low as 3.5 million. And the estate tax is set at a flat 40% now. If what is pending passes, it's going to be much higher and at a much higher graduated rate. So again, if you are sitting at 3.5 million or more per person, you really do want to sit down with your estate planning attorney or financial advisor, take a look at what your planning options may be this year to take advantage of this really high unified gift and estate tax we have at 11.7 million. It could end up saving significant amounts ultimately for your family to be passed on to future generations if you fall in those categories. So it's a little more of an advanced discussion than top 10 mistakes, but I would be remiss if I didn't throw that in. So we're going to open this up to questions here. I am hoping I answered Linda's questions already. Let's see, we have a Lorraine that says, can you drop trust documents for someone that lives in Nevada? I can't. Lawyers are licensed in certain states, and so therefore we can only prepare documents in those states. So we do Arizona documents to answer that. Now, a follow-up question to that is the reverse. Let's say you have estate planning documents that you did in another state and you've moved to Arizona. Somebody always asks me, are my out-of-state documents valid here? And the answer is yes. Asterisk. You always want to get Arizona counsel to look at your out-of-state documents, because even though they are technically legally valid, they will be honored. Arizona has different bells and whistles that we like in our documents, and there are almost always updates we're going to make to your financial power of attorney and your medical directives at a minimum if they are out-of-state documents. Any other questions that I can answer? We've covered a lot really quickly. Again, there are some frequently asked questions. There's a quick estate plan checklist that should be available as a PDF download. People smarter than me with AFW can tell you how you can get those.
Am I on?
I can hear you.
Hi. Stephanie, that was a fantastic presentation, and I got to call my lawyer tomorrow because you just scared me with so many things. I don't think my house is in there, and so informative. And I have some questions that I jotted down and a few that I looked up that I think could be helpful to others. Is an advance directive the same as a living will?
Advanced directives is the general term that applies to the category of all medical directives. So living will, healthcare power of attorney, and mental health power of attorney, yes.
Okay, thank you. Because that's often what they ask. Of course, I was just in the hospital for my foot that I broke, and they're like, do you have an advanced directive? And I was like, I think so. I did throw a question in there. What if I don't have a lot of assets? Do I need a trust? I feel like you answered that quite well, and now I think that I need a trust.
People kind of think the trusts are for like the Rockefeller wealth. They really are not. They're really for working class, everyday people, depending on goals, objectives, and assets. Yeah.
Wonderful. And so if I want to leave a gift to charity, I can do that in a standard trust, right? That's what you're just saying. I don't need a charitable remainder trust or one of these big.
No, you can leave a gift to charity through beneficiary designation, will, trust. The charitable remainder trust, some of those things are what we use for advanced estate planning for people who have significant estates. Otherwise, just distributions how you would. A very tax efficient way, by the way, to leave assets to charity is to leave retirement account assets to charity. Here's why. When you designate a charity as the direct beneficiary for a retirement account asset, the charity gets 100% of that money. There is no income tax that gets taken out. When you instead you leave it to an individual, then there's what's called IRD, income with respect to decedent. There's an income tax on it. So it's a leveraged way to give more to the charity. So sometimes I'll have clients who are like, I want to leave a certain amount to charity. And I'm like, well, let's leave all of this retirement account, 100% of it, because that's the amount you want to leave, coincidentally, and everything else is going to go to the family.
Yeah, and also you were talking about some of the changes. Don't the beneficiaries of an IRA now have 10 years to spend it down?
Yeah. So with the Secure Act, what happened before the Secure Act, anyone who inherited any individual who inherited a retirement account could roll it over and stretch out the required minimum distributions from that inherited account over their life expectancy. Last year with the Secure Act, that all changed. There are now only 5 classes of individuals that can inherit a retirement account and stretch it out. Everybody else has to pull all the money out after the person dies from the inherited retirement account within 10 years. So only a surviving spouse, a chronically ill, a disabled individual, someone who's within 10 years of you, not more than 10 years younger than you, can also stretch. And then kids who inherit, minors, their 10 years doesn't start running until they hit 18 in Arizona. So they get a little bit more time. Yeah. But it's really important to look at your retirement account beneficiary designations in light of the Secure Act change now.
We do have another question in the chat. What if an owner/trustee resides in Arizona but has real estate property in another state with a TODD? I don't know what that means. Does the TODD remain outside the Arizona trust, or can it be included? Anna asked.
Yeah, so I'm assuming the TOD is like transfer on death. So typically when we have clients who live here and have, a vacation or a farm or, whatever, some other type of real estate in another trust, we literally deed that property in the other trust to the Arizona trust. That way we avoid probate there. Now, if that state has something like a beneficiary or transfer on death deed, that's what I'm guessing TODD stands for, that will work as well. So you would have your choice. Yeah.
Great. And we have another question from Maureen at Salt River Project. Can a beneficiary directly roll over their portion of a retirement account to a qualified IRA or retirement account vehicle to avoid paying tax?
Yes. So what happens is if you inherit a retirement account and you roll that over into an inherited retirement account, you don't have to pay income tax at that point on the rollover. But then once it's rolled over into your inherited retirement account, when you pull money out, your required minimum distribution, again, might be 10 years, might be longer, or just as you need it, then you will pay the income tax on the portion that previously grew out that was not subject to income tax. Yeah. Yeah.
Okay. That's a little confusing.
It is.
Melissa has.
It's always super fun to talk about tax, isn't it, gang?
Only when I don't have to pay it.
Right.
Melissa Allers has asked, for individuals who are concerned about an estate tax because of a possible reduction in the federal income tax limits, do you recommend an irrevocable trust?
Sometimes, yes. Now, just so everybody's aware, we were talking about a revocable trust. With a revocable trust, you're the trustee, you're the beneficiary during your lifetime. All the assets in that revocable trust are still included in your estate. So when you die, it's still included for calculation of, are you going to owe, is your estate going to owe a federal estate tax or not, right? What this question is presuming is if you make a gift of your assets into an irrevocable trust, which is not for your benefit, you're not the beneficiary under that irrevocable trust. Maybe it's your children or, you know, somebody else. We can use those irrevocable trusts to make a gift during your lifetime to reduce what you own. So later when you die, there's less that's going to be subject to federal estate tax. And now those assets are in an irrevocable trust for the benefit of whomever you designate, so that it is creditor protection. You've got one person in charge, you know, you've set it up however you want them to have the beneficial use and interest. You can also make gifts directly outright to those same people. That may or may not make sense depending on goals and objectives and that person and their situation. So yeah, I have several clients right now that are going to be making very sizable transfers of assets into irrevocable trusts this year for children, because they want to make sure that they fully use the $11.7 million lifetime exemption amount for estate and gift tax before it drops down. And that can be a really good use. And there's many different types of irrevocable trusts. There's charitable remainder trusts. There's a lot. It's going to be on the scope of our discussion right now.
Also, like a special needs trust would be irrevocable?
Yeah, now special needs trust is totally different. Okay. And we do a lot of those. Oftentimes we make those revocable. When you have a loved one who has a disability, and let's say they're on means-tested government benefits, they can't inherit outright, so you can create what's called a third-party special needs trust, put your assets in that trust for them, either during your lifetime or post-death. But it won't serve to reduce what is included in your estate during your lifetime. Just it has to do with limitations on withdrawal rights of that beneficiary, so they stay eligible. I know. You can't ever get a short answer from a lawyer.
Ever. I thought it was a type of
if anyone does have a loved one that has a disability or a special needs, that's a really unique issue, and it is really important that you do see an attorney with a lot of experience in special needs planning, special needs trust drafting, and administration. Those rules are hyper technical. And there is no one size fits all with that kind of planning. So just a side note.
Thank you. I'm not seeing any more questions. We're almost at time. If we're not, we're a little over. I could just talk to you all day. Thank you. Thank you so much. I want to put up, you're good. Your last slide is up, so that if anyone has a question, they can reach out to you, to us. I also wanted to let everyone know this will be on demand. So if you want to watch it again, the PowerPoint, all the handouts will be available on our website. And actually, you'll get an email saying, thanks for attending. And here's a link if you want to watch it again. So thank you.
You're welcome. Thank you, everyone. Have a great evening.
Good night.
Good night.